An Introduction to Constitutional Law, 100 plus Supreme Court cases everyone should know, by Randy Barnett and Josh Blackman.
Economic liberty through the New Deal. O'Gorman and Young versus Hartford Fire Insurance, 1931, Nebbia versus New York, 1934, and West Coast Hotel versus Parrish, 1937. During the New Deal, the Supreme Court radically altered its approach to reviewing regulations of economic liberty. However, even to this day, many lawyers do not know why and when this change occurred. Our story starts before the New Deal even began. In February 1930, Chief Justice Taft resigned from the Supreme Court due to illness. 1 month later, Justice Sanford unexpectedly passed away. President Herbert Hoover nominated Charles Evans Hughes and Owen Roberts to fill the two vacancies. Though a Republican, Hoover was a political progressive. His appointments began to shift the court to the left. Justice Roberts made an immediate impact on the court in O'Gorman and Young versus Hartford Fire Insurance in 1931. Under New Jersey law, commissions on the sale of fire insurance policies were required to be reasonable. The O'Gorman firm sold Hartford fire insurance policies and requested a 25% commission. Hartford only paid a 20% commission. O'Gorman filed suit for breach of contract. However, the court found that under New Jersey's law, a 25% commission was unreasonable. O'Gorman appealed. He argued that the enforcement of the New Jersey statute deprived him of property, that is the 25% commission, without the due process of law. In April 1930, the court heard oral arguments in O'Gorman with only 8 members on the bench. Apparently, the court split 4-4 on whether the state insurance regulation was constitutional. 3 weeks later, Justice Owen Roberts was confirmed. O'Gorman was then re-argued the following term. Justice Roberts cast the 5th and deciding vote to uphold the statute. Justice Louis Brandeis wrote the majority opinion. First, he found that the business of insurance is so far affected with the public interest that the state may regulate the rates. To avoid the evils of unreasonably high rate levels, the state may limit commissions. Therefore, the New Jersey statute is clearly within the scope of the police power. Second, Justice Brandeis explained that courts must presume the law is constitutional, that is, apply a presumption of constitutionality, unless there is a factual foundation that the provision was not an appropriate remedy for the evils in the insurance industry. Nothing on the face of the statute or facts of which the court must take judicial notice, he wrote, could rebut this presumption of constitutionality. Therefore, the regulation was reasonable. Justice Devanter wrote a dissent that was joined by Justices Sutherland, Butler, and McReynolds. While the majority presumed the law was constitutional, the dissent required the government to justify why the law was constitutional. Justice Devanter's dissent offered the following test. The state could deny O'Gorman the right to make private contracts only if some special circumstances exist that are sufficient to indicate the necessity of the statute to eliminate evils in the marketplace. The key word is necessity. Study guide. Compare O'Gorman to the 3 opinions in Lochner by Justices Peckham, Harlan, and Holmes. Which of these 3 opinions does the O'Gorman majority most closely resemble? Which opinion does the O'Gorman dissent resemble? 3 years later, the court considered another economic liberty case, Nebbia versus New York, 1934. New York law fixed the price of milk at 9 cents per quart. This law was designed to help dairy farmers by raising milk prices for everyone, including the poor. The biggest beneficiaries of the law were large firms that delivered milk directly to homes. Their prices could be undercut by small mom-and-pop stores that did not incur delivery costs. The minimum price for milk protected the profits of the larger firms. Grocer Leo Nebbia offered his customers a special deal to get around the New York law. If a customer bought 2 quarts of milk at the regulated price of 9 cents each, for a total of 18 cents, Nebbia would throw in a free loaf of Italian bread, which was worth 5 cents. With this deal, customers received 23 cents of groceries for only 18 cents. New York charged Nebbia with violating the price control law. He was convicted of offering his customers a discount and was sentenced to pay a criminal fine. On appeal, Nebbia argued that the law deprived him of liberty and property without the due process of law. A 5-4 majority rejected Nebbia's claim. Once again, Justice Roberts was the swing vote, and he wrote the majority opinion. First, Justice Roberts wrote that states can regulate businesses affected with a public interest. That category even included grocery stores. Therefore, under the police power, the government could fix the prices to be charged for the products or commodities it sells. Second, the court applied the presumption of constitutionality that was articulated in O'Gorman. Under this approach, quote, "A state was free to adopt whatever economic policy may reasonably be deemed to promote the public welfare. The requirements of due process were satisfied," Justice Roberts observed, "if the law had, quote, a reasonable relation to a proper legislative purpose and was neither arbitrary nor discriminatory. It was not the court's role to determine if the rule was unwise." Third, the court considered how the law accomplished its purpose, that is, the relationship between the means and the ends. What evils was the government trying to address? Ruthless competition from destroying the wholesale price structure on which the farmer depends for his livelihood. The court concluded that the price control law was not unreasonable or arbitrary, and it had a relation to this purpose. Therefore, Nebbia's conviction was proper. Like in O'Gorman, Justices Devanter, Sutherland, Butler, and McReynolds dissented together. And, like in O'Gorman, they rejected the presumption of constitutionality. Justice McReynolds, writing for the dissenters, observed that the stated purpose of the New York law was to, quote, "increase milk prices at the farm." Yet, the milk distributors were not required to share their increased revenue with the dairy farmers. For this reason, he questioned whether the means adopted, the price control, bore a reasonable relation to the purpose of assisting dairy farmers. Notice Justice McReynolds did not base his analysis on an assessment of the motives of the legislators. Instead, he concluded that the law was really aimed at protecting large milk distributors from competition by mom-and-pop retailers. But why? Because the means adopted do not fit the purported ends of the legislation. Between 1931 and 1937, Justices Devanter, Sutherland, Butler, and McReynolds consistently voted as a bloc to invalidate progressive federal and state legislation. This conservative quartet was dubbed by their critics as the Four Horsemen, a reference to the Four Horsemen of the Apocalypse from the New Testament's Book of Revelations. During this period, Justice Roberts was often the swing vote. In some cases, he would join the Four Horsemen to give the conservatives a majority. And in other cases, like O'Gorman and Nebbia, Justice Roberts voted to uphold progressive legislation. In our next case, West Coast Hotel versus Parrish, Justice Roberts would once again join the liberal bloc. Washington State imposed a minimum wage for women and children, but not for men. Elsie Parrish worked as a chambermaid at the West Coast Hotel in Wenatchee, Washington. Her employer failed to pay her the minimum wage, and she filed suit to recover back pay. The owner of the hotel argued that the Washington law deprived him of liberty without the due process of law. Over the past 3 decades, the Supreme Court had decided several cases concerning economic liberty for women. In Muller versus Oregon in 1908, the court upheld a law limiting the hours women could work. The law was defended based on the, quote, physical differences between men and women. However, 15 years later, in Adkins versus Children's Hospital in 1923, the court invalidated a minimum wage law for women. The federal statute violated the liberty of contract protected by the Fifth Amendment's Due Process Clause. 13 years later, in Moorhead versus New York in 1936, the court reaffirmed Adkins. The 5-4 decision found that New York's minimum wage law for women was unconstitutional. Justice Roberts joined the Four Horsemen. Critically, in Moorhead, the court was not asked to overrule Adkins. However, in West Coast Hotel, Elsie Parrish did ask the court to expressly overrule Adkins. By a 5-4 vote, the court did exactly that, with Justice Roberts once again casting the deciding vote. Chief Justice Hughes, the other Hoover appointee, wrote the majority opinion. He explained that Adkins, decided only 13 years earlier, quote, was a departure from the true application of the principles governing the regulation by the state of the relation of employer and employed. Furthermore, cases decided since Adkins, including O'Gorman and Nebbia, applied those principles properly through the presumption of constitutionality. Because Chief Justice Hughes could not reconcile Adkins with O'Gorman and Nebbia, the court overruled Adkins. With Adkins out of the way, it was easy for the court to uphold the Washington minimum wage law. Quote, if the protection of women is a legitimate end of the exercise of state power, Chief Justice Hughes asked, how can it be said that the requirement of the payment of a minimum wage fairly fixed in order to meet the very necessities of existence is not an admissible means to that end? He added, quote, even if the wisdom of the policy be regarded as debatable and its effects uncertain, still the legislature is entitled to its judgment. This deference is especially appropriate, the court noted, due to the, quote, unparalleled demands for relief which arose during the recent period of depression. Therefore, the law did not violate the 14th Amendment. For one of the last times, the Four Horsemen dissented together. Justice Sutherland, who wrote the Adkins majority, also wrote the West Coast dissent. Here, he questioned the presumption of constitutionality. The dissent explained that a judge has an independent, quote, duty to make up his own mind and adjudge accordingly whether a law is constitutional. A deferential judge who, quote, automatically accepted the views of others, Justice Sutherland lamented, has, quote, surrendered his deliberate judgment. Justice Sutherland also rejected the majority's position that the court should base its ruling on the exigencies of the Great Depression. Quote, the meaning of the Constitution, he stated, does not change with the ebb and flow of economic events. Rather, he added, quote, the words of the Constitution must mean today what they meant when written. A contrary rule would, quote, rob that instrument of the essential element which continues it in force. Finally, Justice Sutherland attacked the law because it imposed a minimum wage for women, but not for men. As a senator, Sutherland had been a strong supporter of the 19th Amendment, which gave women the vote. In his dissent, he boasted that, quote, women today stand upon a legal and political equality with men. Therefore, quote, difference of sex affords no reasonable ground for making a restriction applicable to the wage contracts of all working women, from which like contracts of all working men are left free. Study guide. Nearly 4 decades later, the Supreme Court would hold that the government cannot distinguish between men and women without providing a legitimate basis. On March 29, 1937, Justice Roberts joined the majority opinion in West Coast Hotel, which overruled Adkins. However, only 9 months earlier in Moorhead, Justice Roberts agreed with the Four Horsemen that the New York's minimum wage law for women was unconstitutional under Adkins. How can we explain his change in position? For generations, law students learned that Justice Roberts changed his vote in response to President Franklin Roosevelt's proposal to expand the size of the Supreme Court. On March 9, 1937, 3 weeks before the decision in West Coast Hotel was announced, President Roosevelt announced his own so-called court packing plan.
whenever a judge or justice of any federal court has reached the age of 70 and does not avail himself of the opportunity to retire on a pension, a new member shall be appointed by the President then in office with the approval, as required by the Constitution, of the Senate of the United States.
The number of justices is not specified in the Constitution. It has always been set by Congress. That number has varied from as few as 6 and as many as 10. But President Roosevelt was not concerned with the age or the workload of the court. Rather, he was frustrated that conservative justices had invalidated federal and state progressive legislation. President Roosevelt called upon Congress to use its power to set the number of justices for a very specific purpose: appointing new justices who were more amenable to his New Deal policy agenda and his vision of the Constitution. On March 29th, 3 weeks after the president's announcement, the decision in West Coast Hotel was announced. Justice Roberts was in the majority. His apparent reversal from Moorhead created the appearance that his decision was influenced by the court packing proposal. According to what became the conventional narrative, Roberts voted to uphold the minimum wage law in order to remove the incentive for President Roosevelt to pack the Supreme Court. Since that day, Justice Roberts' vote has been hailed as the so-called switch in time that saved 9, a play on the folksy aphorism that a stitch in time saves 9. In other words, if you mend a small hole now, you won't have to mend a bigger hole later. However, the conventional narrative is not accurate. Roberts did not change his vote in response to President Roosevelt's court packing plan. In 1936, several of the justices recorded the votes cast at private conferences. Based on the records in the docket books, we know that Justice Roberts voted to uphold the Washington law in December 1936, nearly 3 months before President Roosevelt announced his court packing plan. There's a far more mundane explanation for Justice Roberts' switch. In Moorhead, the court was not asked to overrule Atkins. However, L.C. Parrish expressly asked the court to overrule Atkins. And so it did, relying on prior decisions Roberts had joined, O'Gorman and Nebbia. Why does this history matter? Because, according to the conventional narrative, Justice Roberts changed course for political reasons. Therefore, the argument goes, the Supreme Court is an inherently political institution. And because the conventional narrative applauds the switch in time, then a political Supreme Court is a good thing. But the actual history reveals that politics played a different, more subtle role. President Herbert Hoover, a progressive, appointed progressive justices like Hughes and Roberts. These appointments, unsurprisingly, moved the court in a progressive direction. Hughes and Roberts simply had different judicial philosophies about the Constitution than those held by more conservative justices, such as the Four Horsemen, who were appointed by more conservative presidents. Popular elections, not intimidation by political actors, changed the constitutional position of the Supreme Court. The political process by which justices are selected allows for a justice with one principled vision of the Constitution to be replaced by a justice holding a different vision. West Coast Hotel was a byproduct of President Hoover appointing 2 progressive justices in 1930, not President Roosevelt's partisan tactics in 1937. According to the conventional wisdom, West Coast Hotel marked the commencement of what is sometimes called the Constitutional Revolution of 1937. Whenever and however it happened, there is no dispute that a constitutional sea change occurred. Recall that during the same period, the Supreme Court also approved a vast expansion of Congress's powers under the Commerce and Necessary and Proper Clauses. 3 months after West Coast Hotel was decided, the Four Horsemen disbanded. In June 1937, Justice Devanter retired, and in January 1938, Justice Sutherland retired. Justice Butler stepped down the following year in November 1939. 13 months later, in January 1941, Justice McReynolds left the court. During his 12 years in office, President Roosevelt made 9 Supreme Court nominations. By 1943, he had replaced all members of the once conservative court from the Progressive era. Throughout the New Deal, the presumption of constitutionality in O'Gorman, Nebbia, and West Coast Hotel was rebuttable. It was still feasible for plaintiffs to challenge the constitutionality of laws that restrict economic liberty. However, eventually, the Warren Court justices would make the presumption of constitutionality irrebuttable.